Hello, everyone. Welcome to the webinar today. So glad to have you join us. We are talking today about a little bit of a different topic. We've covered tenant screening a couple of weeks ago, I covered it. And now we're going to be talking about something that has, believe it or not, I think even more regulations than tenant screening, and it's employment screening. And I know we have a lot of you coming in right now. So as you're coming in, if you can put your name in the chat and just say hello, I'd love to see who is showing up. It's always nice to see some familiar names. Alicia raised her hand. Hi, Alicia. And we also have a poll question to get us a little warmed up. Hi, George. Hi, Chris. So I'm curious here, just to get us started, how confident do you feel about the employment screening process? I'm going to leave that up for just a little while. I'm hoping if you're here and you're very confident, maybe you just want an update. If you're worried, we're going to definitely be addressing a lot of those potential gaps. So I'll leave that up for a moment. So my name is Alexandra Alvarado. I'm the Director of Marketing and Education at the American Apartment Owners Association. We're doing this webinar in partnership with a few other companies, A Good Employee, Red Trends, and Tenant Alert. And so we wanted to gather all this audience together to talk about employment screening because we know that all of you hire at some point, whether it's your own employees, a property manager, or perhaps maybe you have clients, if you're on the screening side, that run employment screening and you want to advise them as well. So this will all apply to everyone here. It's going to be a general update with our speaker today. So let me tell you a little bit about our speaker, Scott Paler. He's an attorney and partner at DeWitt LLP. I met Scott at a conference in October at a happy hour, and I told Scott, oh my gosh, I've been looking for an employment screening attorney to come and talk to our group because I certainly know about tenant screening, but I don't know anything about employment screening, to be honest. So luckily, Scott agreed to come and talk to the group here. And here we are a few months later. A little background on Scott. He is the chair of the firm's background screening practice group. This is what he does day in and day out. And he uses his niche experience in this area to really advise employers nationwide, everyone from small mom and pops to, Fortune 100 companies. And so really, he has a lot of experience with different clients. So happy to have his expertise here. He's helped with consent forms, adverse action letters, determining if you can reject a candidate based on background screening information, which I know is a big one for all of you, and how to respond to complaints related to your background screening practices, which unfortunately can happen. So I'm going to share the results of the poll question that we have here. Just so Scott can see it too. So quite a variety, right? We have some people who aren't sure. We have kind of a tie here between very confident and worried. So very interesting to see the mix here today. And then I also want to just ask you all as we, hop into it. I won't take too much longer, but what part is actually concerning you the most? So I'd love to hear if it's compliance. Is it the accuracy of the background check results? Is it determining if it's legally safe to take that adverse action, or how the consistency is in those decisions? And that'll also kind of help us here to, guide the conversation a little better. Also, we do have this whole thing recorded. So we're going to be sending this to everyone tomorrow along with the slides. Please feel free to share it with anyone on your team. I know some of you have multiple people who could watch this and benefit from it. So share, share, share. We'll send that email to you tomorrow. And we will also have Q&A at the end of this presentation. So if you have questions, please put them in the Q&A box, not the chat. So the Q&A helps us to keep things in order. So we're going to address those questions there first. I'm sure a lot of you will have questions for our expert here. This is your opportunity to get your questions answered by Scott. So please, if you think of something, put it in the Q&A box. Okay, guys, with all that said, Let me share the results of the second poll. Looks like a lot of it is going to be with compliance forms, notices, and paperwork. So I'm going to leave that up for a few more moments. But Scott, thank you so much for coming to talk to the group. I'm so excited we made it finally happen.
We made it happen. Thank you, Alexander, for having me. Thank you to the association for having me. And thanks to everyone on this call for taking a little bit of time out of your day to spend it with me. As Alexandra mentioned, I've been working on background screening issues for many years, and I can tell you unequivocally that running background checks on applicants and employees is as important or more important than ever before. But what's also true is that the risks associated with conducting background checks in the wrong way, the risks associated with making a mistake in this area, are also higher than we've ever seen before. So we're going to talk about several things today. First, we're going to talk about why it's worthwhile to conduct background checks on, in particular, job applicants and employees. The second thing we're going to do is we're going to diagram for you how the legal risks in this area have escalated in recent years. Why is it more risky today than it was in years past, and how is that legal risk manifesting itself? And the third thing that we're going to talk about, and really the most significant, I think, are very, very practical tips for strengthening the quality of your background screening program. And that's going to be everything from the consent forms and the adverse action letters that many of you just referenced that you're a little bit worried about, to how to decide if you're going to reject someone based on criminal history information or not. Most of today is going to focus on background checks in the employment context. But because I do know that some of you run background checks on independent contractors, on property managers, on vendors as well, I will throw in a few nuggets of information at the end of today's presentation to talk about those types of background checks too. So let's dive in. Where we're going to start is essentially why. Why is it worthwhile to run a background check on job applicants and employees? The first is we want to make sure that when we meet individuals during the pre-hire process, that they actually do have the credentials that they claim to have. They claim to have a bachelor's degree from the University of California. Do they in fact have that? They claim to have a license that allows them to serve in a particular occupation. Do they in fact have that license, right? We know from reading the newspapers, we know from checking online that the amount of resume fraud and the amount of candidate fraud during the pre-hire process has gone through the roof. And so background checks provide one super useful vehicle to make sure people are who they claim to be. The second reason is that sometimes state laws, federal laws will restrict individuals from occupying a certain position if they have a particular background. So if they have a particular felony offense or a misdemeanor offense, or if they have another type of checkered part of their history, they may not be eligible to serve in a particular role. And so background checks provide an opportunity to make sure that people can actually claim the role that they want. The third reason, and I think the biggest reason that most employers run background checks, is to make sure that the individual isn't an undue threat to employees, to customers, to company assets, right? Right now, employers put individuals in a wide variety of positions of trust, right? And that's likely true for everyone on this call as well. And obviously, we don't want to put individuals in a position of trust if they have something in their history that suggests that we can't, in fact, trust them. Fourth reason is negligent hiring claims. Negligent hiring claims have increased substantially in recent years. There was a negligent hiring claim that caught a lot of news attention a few years ago involving a cable company. And the cable company brought on an installer to go into people's homes and to service issues that may arise with their cable service. And the problem that arose is that an individual had some issues in their past history. Those weren't necessarily uncovered during the background check. That individual went into an elderly woman's home and ended up committing an extremely violent act. And a negligent hiring claim cropped up out of that context. And I would ask everyone on this call to think about the amount of money that was assessed against that employer for sending that particular individual with a little bit of a checkered history into someone's home. If you could take a guess, is it under 10 million? Say to yourself, under 10 million, under 25 million, under 50 million, under 100 million, or more? Well, the answer is that the jury that looked at that particular negligent hiring claim initially issued an amount of damages of $7 billion. That's B as in boy, $7 billion, right? And the judge, when asked to reduce that amount subsequent in that case, reduced the amount from $7 billion to $1 billion, right? What I think that case underscores more than anything is that although negligent hiring cases don't pop up all the time, when they do arise, they can involve explosive levels of damages. And background checks are a central tool that's available to employers to try to mitigate that risk. And the last reason I think that employers do background checks as a matter of course is to satisfy business contracts. So sometimes as part of the relationship agreement, there is a provision that will say, XYZ partner of ours will need to run a background check on all applicants or employees that may have a connection to this particular business partnership or this particular business relationship. And so obviously in that context, it's wise to conduct a background check in order to satisfy the contractual provisions. So the lots of reasons to run background checks and many reasons to continue doing so going forward. But how has the risk calculus changed related to background checks? Why are quote unquote bad employment screening practices creating bigger risks than ever before? Well, the first reason is that we're seeing more regulatory attention than ever before. So as you may know, a number of states have enacted laws in the last 10 years or so that restrict the use of credit history information by employers. And we'll talk about that later today. A second trend we're seeing are states and localities enacting Ban the Box and Fair Chance Act laws that are designed to essentially help ex-offenders to reintegrate the workplace. And so those Ban the Box and Fair Chance Act laws that we'll talk about today arise in a number of different formats, everything from limiting the timing for background checks to limiting the amount of time a criminal history background check can go, to requiring employers to consider a variety of factors before excluding someone based on criminal history information. What we're also seeing is a significant uptick in attention at the state agency level related to background checks. So most states across the country have at least one state agency that's dedicated to protecting the interests of employees. And often that type of agency is taking a heightened interest in the way that background checks are being performed. And the last thing to know is, at least until the second Trump administration, there was a significant uptick in attention at the federal level as well. Both the Equal Employment Opportunity Commission, which investigates claims of discrimination, harassment, and retaliation, and the OFCCP, which oversees federal contracting, both of them took a significant interest in the way that employers were conducting background checks. Since the Trump administration has come aboard the second time, that interest has decreased a significant amount. But whether that changes in the future, either within the Trump administration or after the Trump administration leaves, is an open question. So one thing we're seeing overall, though, is a significant uptick in regulatory attention. The second reason the risk calculus has changed is because lawsuits are way up. So in recent years, national commentators have described background screening lawsuits as a new boom, as being on the rise, and even giving rise to professional plaintiffs. So in my home state of Wisconsin, we actually had a headline in our main newspaper saying that there was an individual who basically was just applying for jobs so that he could be subject to the background screening process. And his goal was to find something wrong with the background screening process. And over the course of about a year and a half or so, the article said, he ended up netting settlements of of about $250,000. All right. So he brought a series of cases and settled each of them for between $5,000 and $10,000 to a tune of $250,000 over a year and a half or so. And what that really signifies more than anything is that if this area is so fertile as to give rise to professional plaintiffs, then it deserves a fair amount of attention from employers in terms of trying to get compliance right. One of the reasons that this area has taken off on the litigation front is because it allows a fair number of class actions. So you can imagine if there is a problem with the background screening process as to one job applicant, there very well may be the same problem as to 10 applicants or 100 or 1,000 or 10,000 or 100,000, right? And it's really that type of situation where the same problem crops up again and again and again and again that is most likely to give rise to class action treatment. And so background screening cases often provide a set of facts that is very compatible or that are very compatible with class action treatment. There are particular jurisdictions in the country that are hotspots for background screening litigation, and you see those on your screen right now. Number one, by far, without question, is the state of California. Obviously, the state of California is fertile ground for plaintiffs' attorneys in the employment space. That is absolutely true in the background screening space as well. And there was a recent decision that came out only last week that again is going to increase the chances of litigation in California related to background checks. But California isn't the only state where we're seeing a lot of cases. We also see them in New York and Florida and Pennsylvania and my state of Wisconsin. Those certainly aren't the only jurisdictions where we're seeing them. It just seems pretty clear we're seeing higher numbers in those particular states. It's not just that we're seeing lawsuits, though. It's that we're seeing eye-popping settlements to resolve those lawsuits. And that's another reason why the risk calculus has changed. As you can tell from the numbers on your screen, 2.5 million up to about 5.9 million. Some of the background screening cases can resolve for 7 figures. We see 8-figure settlements as well. And that's largely a product of the class actions that I talked about a moment ago. The more individuals that you have as part of a class action, the greater chance there is that a plaintiff's attorney will be able to extract a settlement in the 7 or 8 figures. So what we've talked about so far is really how the legal calculus has changed, why it's gotten tougher, why there are more risks associated with doing background checks the wrong way than ever before. What I want to turn to now, I think, is the happier part of the discussion today, which is what can you do about it, right? So we're going to go through a series of tips to consider in order to make your background screening program a little bit stronger. The first is to strongly consider using a high-quality professional background screening firm. So I get questions all the time from employer clients about whether it's really quote-unquote worth it to use a background screening company. And the sense I get from those particular employer clients is that they think that maybe they can just do it on their own, right? They can tap into state court. Sometimes there's a state court database that shows criminal history information. Maybe they can just go to that database and get information for free. Isn't that good enough? And I will tell you the same thing that I tell them, which is that having done this for 20 years, I think it is an enormous mistake to try to do background checks on your own, for employers to try to do it on their own. And why is that? Well, the first is background screening companies are professionals at finding information about the right person, right? So when I see HR departments looking at state repositories or looking online, all the time I see mistakes in the way that it's done, right? They don't find things that are out there, or they find things and think it pertains to the right person, but it actually doesn't, right? And both of those situations can give rise to legal exposure. The second reason is that HR departments typically have almost no success finding information out of state. And that's not true for background screening companies. They are well oiled at finding information not only in the jurisdiction where the job applicant or employee lives, but in other jurisdictions as well. A third reason is because background screening companies can help employers to avoid seeing the wrong information, right? So in general, employers don't want to see expunged criminal records, right? Because there's a variety of state laws out there that say employers can't consider expunged records. Well, if employers go online to a state repository or look at the local courthouse, sometimes they can see things like that are better off not being seen, right? Or sometimes they may see old records that criminal history laws that we'll talk about today don't allow the employer to see, right? So background screening companies can help make sure that the information that employers get is actionable. And certainly there has to be communication as to what the employer wants to see and doesn't want to see. But background screening companies can often provide a useful firewall. Fourth thing is that background screening companies do the work pretty fast. Often background checks are returned in a 2 to 3 day period. Generally, HR departments can't do that on their own, and they certainly can't do it well like that on their own. And so often I'll hear from employers that they don't want to wait, but in reality, background screening companies are very efficient in their work. And the last reason is that background checks tend to cost a lot less than people actually imagine. So when I ask employers that haven't run background checks before how much they think they're going to cost, I usually hear a range of between $250 at the low end to about $1,500 ahead at the high end. Both of those figures are much higher than the average employment-based background check. Typically, we see checks in the $30 to $50 range and the $50 to $100 range, depending on the level of comprehensiveness and the number of searches that are performed. But in general, very cost effective, and given the value that background checks offer, more than worth it. Some best practice pointers for finding the right background screening company. It's best to try to find one that's familiar with your particular industry. So I work with several hundred background screening companies. They all sort of have their own subspecialties. It's worth trying to find one that has a long history of working with companies like yours. A second thing is looking for one that focuses on delivering compliance updates. As you'll hear today, there's a lot to know about background checks, and it tends to be difficult for employers to keep track of all those rules. And while background screening companies are certainly not legal advisors, they're often much more cued in to the developments that are cropping up than the average employer. And so many background screening companies will offer compliance insights or compliance updates that at least give employers a head start on where to look next. And I think the third thing to look for is a strong customer service focus. So I think nothing differentiates background screening companies more than the level of customer service attention. And so obviously you want to find one that you feel like you connect with and can trust. But overall, working with a background screening company that's good at what they do and experienced in working with your type of industry is well worth it. Tip number 2, work through the types of searches that the background screening company performs and make sure it suits your particular type of company and the position in question. So a lot of times I'll get questions from employers about, what's the average type of background check? What does it consist of? Well, what you see on your screen right now are the searches that I would say are most common. So if you looked across the board for employers, what are the ones that are run most often? An employment verification to make sure someone worked where they claim to have worked. An education verification to make sure that they have the degrees that they claim to have. A criminal check to try to make sure you understand if there are convictions or pending charges that may be significant to the job. And a sex offender registry check to see if they are an active sex offender. Those 4, I would say, are the most run-of-the-mill checks. One thing to keep in mind is that criminal background checks are not all created equal. There is no such thing as a standard criminal check or a one-size-fits-all criminal check. There's all different types of criminal history searches that can be performed. There are various national proprietary databases that can be consulted. There are state repositories that can be consulted. There are county courthouses that can be consulted, other state courts, federal courts that can be considered. In general, the most comprehensive criminal background check in the employment context is a layered one. So it's a combination of proprietary national database checks and also local and state and federal checks as well, right? So it's basically layering one on top of another to try to make sure you catch the most available information. Outside of criminal history information, though, and the ones you see at the top of your screen, there are other types of checks that are typically available to employers that they can select. And it's worth talking through with your background screening company whether these make sense for you as a business overall or for particular positions. So, social media checks to see whether someone has posted things on their Facebook account or on Instagram or on LinkedIn that may suggest that they're not super suitable for the job that which you might hire them for. Substantive reference checks, OFAC searches, license checks to make sure that they have the license they claim, drug testing, civil record checks. Have they been sued in the past for embezzling money? Have they been sued in the past for committing fraud? Have they been sued in the past for theft? Sometimes that may not show up in a criminal check. It may show up in a civil record check. Do you want to know that? And credit checks as well. And in general, the biggest pointer when it comes to picking the right searches is to try to make sure that the searches that you pick match up with the risks that you're trying to avoid, right? And so it's very much a thought exercise to figure out the right types of checks. And to be clear, many employers run one set of checks for certain types of employees, and then they'll run different types of checks for others. It doesn't have to necessarily be a one-size-fits-all situation. A third tip, think about waiting until the conditional offer stage to conduct the background check. So this tip arises for a few different reasons. One is that an increasing number of jurisdictions around the country now require employers to wait until the very end of the pre-hire process to run the background check. And there's all different public policy reasons for that. But in terms of today's presentation, I think the most important thing to know on that issue is just that type of restriction is becoming more and more popular. Waiting until the conditional offer stage also isn't a bad thing for your pocketbook, right? So it saves money, right? If you're ultimately going to exclude someone for a different reason, you don't necessarily need to spend the $30, $50, $100 or whatever on the background check, right? The third reason to consider waiting to a little bit later in the pre-hire process is because it's often safer to exclude people on other bases, right? So as you saw from the early part of this webinar discussing the rising legal risks, right? If you're going to exclude them or reject them based on something entirely separate from the background check, why not do that before you run the background check? Because once you run the background check, there is a presumption that you considered it and that you factored it into the hiring calculus. And so depending on what comes back and how risky it is to use that information, it may just be safer to exclude them before you ever have gotten to that point. It's wise, and it's a pretty standard practice at this point for employers to make clear in the offer letter that the offer is conditioned or contingent on completion of a successful background check, and that is usually a wise way to go. Let's move on to tip number 4. If you are using a background screening company, if you're using a consumer reporting agency to conduct a background check, make sure to get written consent right. I was just talking to another one of the background screening attorneys that regularly practices in this area. I was just talking to him earlier this week, and he said again that from his perspective, the number one way that employers can get sued in the background screening area is with faulty written consent materials. I think reasonable minds can disagree about whether that's really the number one way or not, but it is indicative of the fact that this is one of the higher risk compliance areas, and it's something that a number of you mentioned in the survey that Alexandra put out to you. So let's talk about getting written consent right. What are the rules and what are some best practices to consider? So the federal law that governs background checks by employers is called the Fair Credit Reporting Act. Now, even though you heard me use the word credit, the FCRA applies not just to credit checks, but to criminal checks done by a background screening company, employment or education verifications, drug testing done by a consumer reporting agency, or really any type of background check conducted by a consumer reporting agency. So the FCRA applies to that context. And what the FCRA says is that In order for an employer to conduct a background check on a job applicant or an employee, the employer first has to deliver a written disclosure to the job applicant or employee announcing the background check. And really, all the FCRA says has to go into that disclosure is a statement that a consumer report, which is a fancy word for a background screening report, a consumer report may be obtained by the employer for quote unquote employment purposes, right? That's really all the law says. But what the law also says is that that particular disclosure must stand alone. It can't be combined with almost anything else, okay? And what plaintiffs' attorneys have said with some success in recent years is that a disclosure is invalid if it includes extraneous information. So essentially, if the employer throws stuff into the disclosure announcing the background check that doesn't need to go into that disclosure, then it is arguably improperly combining the disclosure with other extraneous things, rendering the disclosure invalid. So essentially what the plaintiff will say is, the company never had real consent to run a background check because they provided a faulty disclosure to the individual. In addition to the FCRA, multiple states have rules that identify disclosures or authorization requirements at the consent stage. And so it's important to take into account those state rules as well. What you see on the bottom of your screen are examples of companies that I'm sure all of you are familiar with that have been hit by background screening consent lawsuits over the years, right? Whole Foods, Publix, UBS, Domino's, Barnes and Noble. I could go on and on. I once gave a presentation like this, and one of the individuals in attendance raised their hand and said, yeah, you basically go down any average street in America and you see company after company that's been hit by a background screening consent lawsuit. And I think to some degree that's true. This is fertile ground for the types of class actions that I identified at the beginning of today's presentation. So what are some best practice pointers or some ideas for trying to avoid consent-related risks? Well, the first thing is to make sure the disclosure is not in your employment application or part of a larger document, right? So I'll still see situations where companies will throw language in the bottom of the employment application that says something like, by signing the employment application below, job applicant is consenting to a background check and realizes that if they're hired, it's on an at-will basis, right? That type of language thrown into the bottom of an employment application is not effective because it's being placed in the wrong location. The disclosure has to stand alone. It can't be combined with an employment application. In more recent years, though, what we've seen largely are situations where employers are accused of throwing too much information into the disclosure. And so what you see on your screen right now are examples of things that have gotten companies into trouble. Releases of liability. So the company says, applicant understand background check. If the employer is running a background check on them, that they agree that the employer is going to be held harmless and released from any and all liability related to that background check, right? We see that type of release of liability language frequently in America, but in this context, it can get people into trouble. Or at-will statements suggesting that if the job applicant is hired, that they're going to function as an at-will employee. Or even discussions of rights, right? So background screening rights under the Fair Credit Reporting Act or background screening rights under state laws. Sometimes employers will throw those sentences into the FCRA disclosure just to try to make everything compact and efficient, but it's getting employers into trouble. One of the more comedic ones we've seen in recent years was an employer that got into trouble for leaving in, this is only a sample document, into the background screening disclosure. So the background screening company had provided a sample document and they marked it that way at the top just to make sure that the employer knew that they owned ultimate responsibility for it. Well, the employer, a large one, inadvertently left in that sample document language, and then they faced a large class action related to it. In terms of state law, the biggest area of concern without question is California. California essentially requires its own page of text. And so if you are going to run background checks in the state of California, it's wise to make sure that you adhere to all of the specific consent requirements that California lays out. Moving on from consent. Under the Fair Credit Reporting Act, so again, if you're using a background screening firm, the law does not allow an employer to just take action against a job applicant or employee based on a background screening report and never disclose it to the job applicant or an employee. The FCRA requires that the employer go through a specific process. And the process really consists of 3 steps. So if the employer is planning or thinking about taking adverse action based on the background screening report, the FCRA says the employer has to provide the job applicant a copy of the background screening report and a federal governmental notice called a summary of your rights under the Fair Credit Reporting Act. And then after providing that notice, the employer has to wait a reasonable period of time for the job applicant or employee to identify errors or inaccuracies in that report. And then assuming that the job applicant or employee does not identify any inaccuracies and the employer is going to move forward, then the employer would send out an adverse action letter to the job applicant or employee that contains very specific information that's required under the Fair Credit Reporting Act. So it's a 3-step process. So before an employer can actually reject someone based on criminal history information from a background screening company, credit information, employment, education verification, they have to go through this process. What you see on the bottom of your screen are example targets, again, that you almost certainly know that have faced adverse action related lawsuits over the years. And so, again, it's indicative that even large, very sophisticated, smart companies can face allegations that they didn't comply with these adverse action rules. It's not just federal law that matters, it's increasingly state and local law that matter as well. This is one of the biggest areas of change in background screening in recent years, is that states and localities have enacted a number of laws that require employers to dish out additional information at the adverse action stage. So New York City and Los Angeles require employers to go through a long list of factors in writing and distribute that writing to the job applicant or employee at the adverse action stage. Illinois and a number of other jurisdictions require the employer to identify the part of the report that's causing adverse action. And that's particularly true if it's criminal history information. And so it's become sort of a whack-a-mole situation where increasingly employers have to pay attention to these state and local laws that are emerging and make an effort to comply with the supplemental adverse action requirements that they are imposing. What are some best practice pointers? Well, I think the first one, a number of employers will use their background screening company to send out adverse action paperwork on their behalf. And if that's true for you or for people on this call, it's important to make sure that that process is super well oiled, because ultimately, if the adverse action letters don't go to the right place or don't say the right thing, generally it's the employer that's going to own responsibility for that. It's really important to remember that it's both a pre-adverse action letter and a post-adverse action letter. I see situations all the time where employers inadvertently send just one or the other. And the third thing to remember, as we talked about, is state and local law requirements are increasing. And so to the extent, particularly that you're a multi-state employer, it's really wise to think about how you're going to keep track of those emerging state and local laws and then make an effort to comply with them. The 2 ones that are coming out, we know already so far in this year, the city of Philadelphia has introduced new adverse action changes, and the state of Washington has new adverse action changes that take effect starting this summer. Tip number 6 is carefully consider criminal history information. So it used to be, in my experience, that many employers would just have sort of no felons allowed rules or no convicts allowed rules. They'd put that in writing, and generally they would never be challenged on it. In the last 10 to 15 years, that has fundamentally changed. The risks associated with sort of a no felons or no convicts allowed policy has increased substantially. One of the main drivers for the change in criminal history usage regulation was the Equal Employment Opportunity Commission's 2012 guidance, which suggested that employers could face an investigation or a disparate impact race discrimination claim from the EEOC if the EEOC did not believe that the employer was following a multi-step process to evaluate criminal history information. And what the EEOC said is that an employer should just not have the no felons or no convicts allowed policy that I mentioned a moment ago. Instead, they should go through a multi-factor analysis. First, they should evaluate whether there is a relationship between the job and the crime. Is it really connected or not? So, for example, think about felony driving under the influence, right? Well, if an individual is going to be driving as part of their job, then felony driving under the influence may very well be job related. But what if an individual is only going to work in an office and never drive as part of the job? Or they're only going to work on a manufacturing line and never drive as part of the job? Then is it really job related? The EEOC, at least back then, would have said probably not. And what the EEOC also said in its guidance is that employers should factor in the amount of time that has passed since the conviction. So it's one thing to look at a conviction for assault that came to be in 2021, only 5 years ago. It's another thing to look at an assault conviction that arose in 2008 when someone was 18 years old. Right? They may not be the same person anymore. It's very old, right? And so the EEOC said you should look at all those different factors and make a reasoned assessment about whether a crime is or is not substantially related to the job. And then they say, don't stop there. What they said is that assuming you found that it was substantially related to the job, then you should evaluate how the individual has grown or developed since the time of the crime. Have they gotten new training? Have they worked in similar jobs? Have they gotten new education, right? Are there signs that they're a different person and less of a danger to you, the employer, than they were at the time of the crime? And the EEOC said you should factor that in as well. And only if you found that it was a substantially related conviction that was not mitigated by their more recent behavioral improvements or conduct, only in that situation should you consider excluding them. Now, in the last year or so since Trump took over a second time, they've largely walked away from those rules. I would say those rules right now are likely not being pursued at the EEOC. However, it's important to understand that foundation because that foundation gave rise to state and municipal law changes across the country. And regardless of the EEOC's position, those state and municipal law changes very much remain in place. What you see about halfway down your screen are just a handful of jurisdictions around the country that have laws that materially limit the way that criminal history information is used. They may say that a conviction can only be considered if it's substantially related to the job. They may limit, like San Francisco, the amount of time that an employer goes back and only look at crimes, let's say, within the last 7 years. Or Massachusetts, Massachusetts says that employers shouldn't consider certain types of misdemeanor offenses, particularly after a few years have passed, right? The most significant recent change to me is the state of Louisiana. The state of Louisiana is historically considered a red state, a more conservative state, a more business-friendly state. Well, Louisiana passed a law only a few years ago that again introduces a substantial relatedness requirement and said employers should only consider convictions that are substantially related to the job. And that was a sign to me that this area is becoming more of a bipartisan issue and that we should continue to expect a patchwork of state and local laws across the country, but maybe even more in red states than previously thought. California, Illinois, and New York are part of a new wave that require the type of individualized assessment that I referenced before with the EEOC, where employers are supposed to look at how individuals have grown and developed and improved themselves since the time of the crime. That's a big change, and a lot of employers are not yet accounting for it. A number of companies, again, that you would know have been hit with cases alleging, right, that they improperly considered criminal history information. So this isn't just a theoretical issue, it's a practical issue as well. What are some best practice pointers for employers that are considering criminal history information? Well, the first thing is probably to get rid of any sort of blanket policy saying no felons or no convicts allowed. A second thing is it's one thing to consider pending criminal charges, right? So I'm being, let's just say theoretically, I'm being accused today of misdemeanor assault, right? That may be substantially related to my job. But let's say I was charged with assault 10 years ago and the assault charges were dropped. Many of these laws that have emerged in recent years have basically said employers should not be allowed to hold non-conviction information against a job applicant or an employee. So if you're going to sort of establish an across-the-board rule in every state, it's likely wise to not consider charges that did not result in a conviction. A third thing is to analyze whether criminal history information that is found is job related and probably to give more weight to more recent crimes. A fourth thing is to factor in those jurisdictions that require individualized assessments. So we talked about California and New York and Illinois. You see now on your screen, there are municipalities like New York City and Los Angeles that require it as well. So it's an important concept to keep track of what those jurisdictions are, because often they require individualized assessments in writing. The second to last bullet point relates to criminal history matrices. So when I began working in this space many years ago, a lot of employers, particularly large employers, would have sort of a spreadsheet that said something like, if this, then that. So if the individual was convicted of murder, then reject. If the individual was convicted of rape, then reject. If the individual was convicted of battery, then reject, right? It was very much black and white. If this, then that. And it was designed to try to maintain consistency within an organization. I completely understand how that makes sense, but it runs counter to the direction of most of the laws that have come out in the last 10 years or so. All of those are directed more towards custom case-by-case assessments. It's a little bit more like, disability reasonable accommodation analyses that some of you may deal with in the employment world, right? Where it's a case-by-case fact-driven analysis, multi-factor analysis, right? And so those types of matrices that are very black and white, if this, then that, are sort of out of favor today, or at least they need to be tailored or curated a little bit to try to account for the laws that suggest that type of black and white rule is no longer kosher. And then finally, again, there are just so many states and localities that are coming out with new restrictions and new requirements in this space. And so one of the recipes for continued success in this area is to have some procedure for trying to stay on top of these laws or to work with attorneys that do. A couple more tips, and then we'll get to a non-employment slide and move on to your questions. The amount of employers that run credit reports is now lower. I would say the percentage of employers that does so continues to decrease. Now we are certainly well under half. And if I had to guess based on my experience, we're probably down to 25 or 30% of employers that run credit checks in any context. One thing to know is that a credit check is not going to include a credit score. So unlike a mortgage situation or a tenant rental situation, something like that, where a credit score is going to be part of the analysis. In the employment world, the credit bureaus do not include a credit score as part of the credit report. So generally, if an employer is going to get a credit report in the employment context, it's going to include signs of delinquencies and of collections activities and potentially of bankruptcies. Those are really the three things that you might find in a credit report. In recent years, a number of states have introduced laws and enacted laws that are designed to make it harder for employers to run credit checks because many states just don't believe that they're all that job related. And at least before the Trump administration, the EEOC took that perspective as well. So to the extent you are operating in multiple different states, and particularly if you're operating on either the East Coast or the West Coast, there very well may be a state law that restricts or prohibits your usage of credit history information in the employment context. The biggest change in this area coming up soon is in the state of New York. Beginning in April, the state of New York is all but prohibiting credit checks in the employment context. There's a handful of exceptions. Those exceptions will not apply to most employers. For the most part, credit checks in the employment context in New York are all but dead. There are several cities on top of the states that impose restrictions on credit checks being done. DC is one of them. New York City is another, and we expect those jurisdictions to continue to increase. When I'm talking to employers about the possibility of running credit checks, generally what I'm recommending to them is that they only run credit checks if they are plainly job related. One type of position that I think is likely to be job related is like a CFO position or a head of accounts payable, something like that, where someone is involved in actually making payments or payment decisions on a regular basis. There's an argument there that the credit check is related. But for your average run-of-the-mill job, most of them aren't all that job related. And it's important, again, to account for state and municipal laws that continue to emerge. Last tip before we get on to non-employment checks for a quick minute. If you, in light of a presentation like this, are sensitive to the legal risks that attach to conducting background checks, or you worry about the possibility of a single plaintiff or a class action lawsuit in this space, there is the possibility of getting insurance coverage to try to tackle that risk. Many of you on this call may have employment practices liability insurance. One thing to know is that an increasing number of EPLI policies have a carve out for background screening claims. They're worried about these type of claims. And often those carve outs are written in the manner that I identified in the middle of your page. So they'll either carve out FCRA claims or consumer protection claims, privacy related claims, or class action claims. And so if you are concerned about having meaningful insurance coverage for the possibility of a background screening claim in the employment context, it's worth taking a close look at your insurance policy or having your attorney do it to try to make sure you have the coverage that you want. It's also worthwhile to check the maximum coverage numbers. Sometimes there is a sublimit, for example, for class action claims at $100,000 or $250,000. As you saw at the outset, sometimes the background screening settlements can far exceed $100,000 or $250,000. And so if that's you, if you're sensitive to that issue, it's worth making sure you understand what the coverage limits look like. I want to move on away from employment checks for a minute to some other checks that you may be running. So I know some of you may run checks on property managers, or you may run checks on vendors in different contexts. A few things to keep in mind there. One is it's generally best to still assume that FCRA process requirements apply. And so what that means really is two things. One is getting consent right, written consent right, and the second is getting adverse action paperwork right. On the written consent, it's important to tailor the wording for the circumstances. So if you're not actually employing them, it's probably not too wise to use employment language in the written consent. It would likely need to be tailored to the circumstances at issue. And then for adverse action in the employment context, it's generally the pre and the post letter, as you heard about a little while ago. Sometimes outside of the employment context, companies will only send a post adverse action letter. In many circumstances that can work, but sometimes there are close lines as to whether it fits underneath the employment purposes prong or not. And so if it's a close call at all, it's often best to include two letters instead of one. One nice thing is outside of the employment context, there are generally far fewer rules on the usage of criminal history information and the usage of credit history information. So that's nice, less restrictions, less potholes. But I would point out that there are some fair chance laws, like in Los Angeles and in New York City, that do pertain to independent contractors or individuals that are not necessarily designated as W-2 employees. And so it's not quite as clean as just assuming if it's someone, quote unquote, considered an independent contractor, that means that none of the fair chance background screening rules come into play. It's a little bit more nuanced than that. And with that, I want to turn it back over to Alexandra, and I'm excited to hear what questions you might have.
Yes, thank you so much for that presentation, Scott. It was really thorough. You went through so much. So we definitely have some questions that are coming in. A reminder to everyone to put your questions in the Q&A box, not the chat. I'm also going to launch a final poll question for you all to answer while we're doing Q&A. If you would like more information about agoodemployee.com, that's AAOA's partner that does employment screening specifically for employers and property managers, whatever you're looking for. Let us know if you want us to email you some information or we can schedule a call. I'll leave that up for a moment. All right, so the first question is from Wendy. If you haven't recently done background checks, but you want to start now, can that now be considered discrimination?
That's a great question. So the general answer is no, right? So employers all the time make a determination that they're going to introduce a new policy. And typically, as long as that new policy is introduced in a neutral way and applied consistently going forward, there's not much of a risk of a discrimination claim. Generally, when discriminations pop up is when there is disparate treatment, right? But if you introduce a policy and you say starting whatever, April 1st of 2026, we're going to start running background checks on new job applicants, it would be very difficult for a plaintiff's attorney to mount a discrimination claim in that context.
Yeah, that makes sense. Reza is asking, is the screening for potential tenants and employment the same? This was earlier on in the presentation. So I think you explained a little bit of the differences, but just to give us some takeaways on what's the difference.
Yeah, so there are differences. So, you heard me talk at length about written consent requirements in the employment context and how sensitive we have to be on formatting and on wording. In the tenant screening context, fortunately, it's not nearly that sensitive. You have to get written consent, or at least it's a recommended best practice to get written consent, but the formatting and wording are less susceptible to attack. Also, in the tenant screening context, a landlord or property manager only has to send a post-adverse action letter. They don't have to do the pre-adverse action letter, the waiting period, and the post-adverse action letter. So those are two big changes between the two.
Thanks for clarifying. Luann is asking, are active or recent PBJ cases reportable, meaning the probation ends on a future date? So PBJ meaning the probation before judgment.
Yeah, so there's all different types of what I'll call diversion matters: adjudications withheld, deferred adjudication, diversion, probation before judgment, things like that. Background screening companies vary in the way that they report them. In general, those matters can be reportable for up to 7 years, but there are certain states where background screening companies may not be able to report them at all.
Okay. Ari asking, since people in the multifamily industry frequently interact with families and kids, are we allowed to avoid hiring sex offenders, or is that considered discrimination?
Yeah, so that's a great question. So whenever there's a can we question, it generally comes down to state and local law, right? So the first thing I would be asking a client in that context is what state or local law comes into play, right? There are a variety of states. The overwhelming majority of states place no restriction on the ability of employers to use sex offender registry information. So in the vast majority of places, pretty good to go. There are a smaller number of states, like California, that do restrict the usage of sex offender registry information. California, for example, says an employer can only use sex offender registry information in the employment context to protect a person, quote unquote, at risk, right? And so the big question in California is, will the employee be exposed to individuals that are considered, quote unquote, at risk? Now, the questioner brought up an example involving kids, right? And potentially going into a home. Certainly, my hope would be in that type of context that children in a home would be considered persons at risk. But lawyers fight about that type of thing all the time. And so it would be important to work through that issue with counsel.
Yes, thank you for clarifying. That's a great question. Haley asking, what is a reasonable amount of time? This came up when you were talking about, I think, the pre-adverse, adverse decision sort of timeline there.
Yeah. So the FCRA itself does not say how long an employer has to wait between the pre-adverse action letter and the adverse action letter. Most people, based on some advisory opinions from the federal government that came out many years ago, say at least 5 business days. And the goal is to give the individual, quote unquote, enough time to say that there's something wrong with the report. But what I would also say is an increasing number of states and localities are introducing specific timeframes. And in particular, in various locations in California, there are all different timeframes that are being introduced. Likewise, in Philadelphia, there are specific timeframes that are being introduced. And so it's important to make sure you understand the laws that apply in your particular jurisdiction.
Yes, well said. Luann was asking here, who or what is the best source for providing all these new ongoing state and local laws? We use BRB publications.
Mm-hmm. So there's a variety of different offerings in today's AI world. Those offerings are multiplying. I'm probably not here today to identify any one source, but what I would say in general is that you want to look for reputable organizations. So if you're going to go online, look for reputable organizations that have a strong presence and experience in the space. Work with attorneys that have regular experience and expertise in the space. Attorneys can often put people in touch with 50 state surveys and updates that may be useful. And then there are various publications that are available as well that will at least provide synopses of state and local laws that are in place up to that particular point in time.
Yeah, there's so much out there now, right? Cameron is asking here another question. What if you want to do a background check on a limited partner in your property and you don't have written consent for this request?
Right. So that's more of a risk management calculus. So, anytime we're potentially operating outside of the Fair Credit Reporting Act, or we're taking the position, right, there are risks that can come into play in that type of scenario. So when I'm talking to clients about that type of scenario, we're talking about really whether there's an argument that we don't need consent. Sometimes there is, and sometimes there isn't. We're also talking about whether it makes more sense to ask for consent, because a lot of times in these situations, it's really just as simple as going to the other person and saying, we want to do this, and here is why, right? But different situations sort of require different strategies.
Yeah, absolutely. And I think it's a good idea, actually, to run a background check on that potential partner if you're going to go into business with them.
For sure.
Yeah. James is asking here, what is generally considered relevant behavior for research-based social media checks? Focus on identifying risks that could impact the place of residence or employment/vendor.
Yeah, great question. And social media checks are becoming hotter and hotter, and for good reason, because that's where a lot of people spend their time. And also, it provides sort of an unvarnished look behind the curtain, right? Because people may present themselves one way during the application process, but then you look at what they're saying online and you see a very different person, right? What I would say in general, in terms of what social media background screening companies look for, they're often looking for comments or signs of violent behavior. They're looking for inappropriate language. they're looking for threats against other individuals. They may be looking for signs of criminal drug activity. That's another one. They may look for disparaging comments about prior employers. There's sort of a variety of different buckets. But the main goal for social media companies is to identify potentially relevant information that ideally does not fall into any of the protected characteristics in Title VII or state law. So you don't want to run into the fair employment law issues, right? So avoiding things like, signs of cancer treatment, or avoiding things that religious minority or prior member of a union, right? Protected characteristics that it's better for employers not to know about. And so social media background screening companies are trying to provide potentially juicy or useful information that doesn't fit into those fair employment categories.
Yeah, absolutely. I could see that quickly going the wrong way when you find something out about someone. Okay, another question. Can these checks be performed occasionally when an employee is already onboarded?
Yeah. So, yes, in general, background checks on existing employees are permissible. So, I routinely see employers conduct rechecks every 2 years or 3 years or 4 years. Now, some background screening companies also offer the possibility of continuous monitoring for criminal records or driving records, depending on the particular situation. So, all of that is potentially permissible. But one issue is getting consent right? So if you're going to run background checks, not just at one point in time, but in a recurring way, it's important to think through consent, among other things.
Yeah, that's a good point. Okay, another question from Nini or Nene. Can you recommend any professional background screening firms? Well, we do have a partnership with agetemployee.com, so I have to tell you about that, of course.
Yep.
Scott, are there any others that you found in your practice that are good for this audience? You work with
Yeah.
so many.
Uh, yeah, I work with several hundreds. I probably am not going to name all several hundred, but here's what I would tell you is that one of the things I would look for in a background screening company is a dedication to compliance, right? So we talked about customer service earlier, but compliance is equally or even more important. Generally, compliance-minded background screening companies are connected to the Professional Background Screening Association. It's the largest trade group in this area. And it also has accreditation criteria and all sorts of different compliance training sessions and whatnot. And so that's one of the things that anyone on this call can potentially look for is a background screening company that is closely connected to PBSA.
Wonderful. Yes. And A Good Employee is a member of PBSA as well. And so we did invite the A Good Employee clients from our partner, right? And so some of you are on this call
Right.
now. Art is asking another question. So he's a small property owner with less than 13 units looking for an on-site manager. How do you protect yourself from an expensive lawsuit in California?
Related to background checks or negligent hiring
Really,
or what?
right? Because you can get sued in
Yeah.
multiple ways. But for
You
background
can,
checks, I think, yeah.
yeah. Yeah. So, whenever I'm dealing with someone in California, it's like we have to be extra careful, right? And so,
Mhm.
really, what that means is going through a lot of the areas that we went through today. It's making sure consent is carefully constructed and on point, making sure the adverse action letters have the right content and are sent out at the right time, evaluating criminal history information in the nuanced way that California law and California municipalities like San Diego and Los Angeles and the county of Los Angeles require, right? Going through that very careful analysis, being very sensitive to credit check restrictions in California, things like that. So a lot of the areas that we covered today are sort of the seedling start for trying to get that right.
Right. Yeah. And A Good Employee does also offer some guidance on that. An attorney always is going to be your best option, though, to get like the best, most updated, hyper local kind of information. Cameron is asking, what is your exposure if you get a background check on someone without their consent?
Yeah. So if you get a background check on a job applicant or an employee without their consent, there's various types of claims that can be asserted. But in a lot of times in those situations, it's not just one employee, it's more than that. And so that's where the possibility of a claim can come in. But the under the Fair Credit Reporting Act, which is just the federal law in this area, they have the possibility of getting actual damages. They can get statutory damages of $100 to $1,000 per violation. They can recover attorney's fees, and punitive damages are uncapped under the Fair Credit Reporting Act. So, in a situation like that where consent is not obtained, often there's a reckless or willful argument. And then emotional distress damages are available in an uncapped fashion as well. So, that's just federal law. And then state law potentially has things as well. Like California has a minimum of $10,000 per violation, even in the absence of actual damages.
Wow. Okay. Well, there you have it. A lot of you are in California, so watch out. Okay, so I don't see any more questions coming in. Scott, you covered so much. I'm so excited to share the recording with those that couldn't come. And for those of you who are still sticking around, I will be sending the recording to everyone, including Scott's contact info, so you can reach out with further questions and or consult with his firm, and also the A Good Employee website information if you did want to get started on that, and start screening if you aren't already. So thank you so much again. Hope to have you back sometime in the future, Scott. This is a fantastic presentation.
My pleasure. Thanks so much for having me, and thanks to everyone who tuned in today.
Take care, everyone. Bye.